For the purpose of creating a trust, the author of the trust indicates with a reasonable certainty in relation to the intention to create the trust and trust property, beneficiary, and the purpose or object of the trust. That's why we have seen three certainties of the express trust. In the knight versus knight, three certainties, first of all, created, and thereafter it was incorporated into the law. When we see the first certainty of this matter, that also we have seen reasonable certainty under section 6 of the trust ordinance. The trust may be created when the author of the trust indicates with a reasonable certainty by words or acts the intention to create the trust, purpose of the trust, beneficiaries, and trust property. We have seen in the previous lectures what is known as intention to create the trust. There may be moral obligations or there may be fiduciary obligations. Fiduciary obligations create a trust. Moral obligations may or may not create a trust. It depends on the facts of the case. Then we have seen the interpretation of precatory words, and we have seen the beneficiary also. In the beneficiaries we have seen the beneficiaries must be certain. If the group of beneficiaries, say suppose it is for the law students of the law college or sometimes poor people in Sri Lanka, then that's a group of people. In that we must identify the specific beneficiaries. The law college student, who are the members going to get the beneficial interest? Then we must say A, B, C, D. Likewise, in the poor people of Sri Lanka, we must define who is the poor people, who are the members there. We are going to give some sort of beneficial interest to them. Then we must identify. Finally, we have seen the beneficial interest also. How much of beneficial interest that we are going to give. Then these are the matters must be certain. Today in this lecture, we are going to see the certainty of trust property. The subject matter of the trust is the property in respect of which the trust has been created. As we have seen, if there is no property, if there is no trust property or the subject matter or the trust fund, then there is no trust at all. Property is the backbone of the trust. No property, then no trust at all. Then first of all, we must see whether we are able to identify the trust property. This is one of the essential ingredients in the express trust. For the effective creation of trust, the certainty of trust property is the subject matter that should be very certain. The property subject to the trust must either clearly defined or be capable of ascertainment. This requirement has a number of aspects. When we see the trust fund must be identifiable. Trust in which the property is mixed with other property so that it is impossible to identify precisely which property is held on trust will be invalid. Then always we must be able to identify the trust property or the trust fund, and also it should not be mixed with any other property. If it is mixed with some other property, it's very difficult, or sometimes we can say it is impossible to identify the trust property. Therefore, as a result, the trust is void. That's why when we see the act also, we have seen trust property must be certain. For creating a valid trust, it is necessary that the subject matter of the trust is defined with a certainty. In whatever deed of transfer or deed of trust or deed of gift or whatever it is, the trust property must be defined. Generally, in the deed of transfer, you would have seen there must be a schedule in the schedule to the deed. In the schedule, the boundaries of the land will be demarcated. Here also, it is very important. We must be able to identify the trust property or the subject matter of the trust. And also it should be such which is capable of disposition. The property includes any property which a person can in law transfer, assign or dispose of inter vivos or under a will. Now we will move to other slide here. The subject matter of the trust must be the property transferable to the beneficiary. Then the property is there. First of all, we must be able to identify how. Then the second issue is the property must be able to transfer to somebody else, especially for the beneficiary. But generally, we can say transferable to the beneficiary. It must be able to transferable to the beneficiary, but not always. Sometimes it may be transferred to author of the trust again. It depends on the terms and condition of the trust deed. So any property inalienable by law cannot be a subject matter of the trust. The subject matter of the trust must be the property transferable to the beneficiary. It must not be merely a beneficial interest under subsisting trust. Suppose there is a trust, say 1 million rupees deposited in a bank account. Then say about 10,000 rupees we are getting every month. Then we can't create another trust on these 10,000 rupees, because this is a beneficial interest of that principal deposit. That is the trust already existing. Therefore, you can't have another trust on the beneficial interest of another trust. That's why, in other words, there cannot be trust upon a trust. Now we will move to other slide here. There must be certainty both of property intended to affected by trust and as to the beneficial interest to be taken by each of several beneficiaries. That we have already seen when we see the certainty of beneficiaries. We have seen not only the beneficiaries must be certain, but also beneficial interest. How much of beneficial interest that we are going to pay to the beneficiary, that also must be certain. Where there is uncertainty as to the property, it is evident that there can be no transfer of title, and purported transferor is never divested his title. First of all, we must be able to identify the property. If there is no property identifiable, then there is no transfer, because you must, when you say this is a land that I am going to create on this land, this is a land vested or that I am going to allocate for the trust. Then first of all, I must have the power. I must have the ownership of the land. Then I must be able to identify the property. Then this is a land. Then I must be able to transfer the title to somebody else. If I am unable to identify, then how can I transfer the property? Suppose if I create a trust, I say that my land in Cinnamon Garden. Then which land? If it is one and only land, sometimes the court may interpret to create a trust. But sometimes, if it is more than one lands, then what is the situation? Which land, the trust created on which land? That's the issue. Then the main issue is here, we must be able to identify the property. Then that property should be transferred. Then that property should be transferred in the sense title must be with the owner. Then the owner of the property must transfer the title to the trustee. If there is no title, then there is no trust at all. Where the certainty of intention, property are present, but the beneficiaries are uncertain, then it would be resulting trust under section 85 of the trust ordinance. We will study the constructive trust separately, under which we will see sections 83 to 98. 85 also one of the main sections that we are going to see. Now for the purpose of here, what is the resulting trust that we have already seen when we see the classification of trust. Resulting trust in the sense, now if we say suppose the author of the trust created a trust and transfer the property to trustee for the benefit of certain people, but beneficiaries are not clear. But the property already transferred to trustee. In that case, trustee must hold the property for the benefit of author of the trust. That's known as resulting trust. That's why here, if the intention is clear to create the trust, property is present, property is clear, certain, then the beneficiaries are uncertain, then resulting trust, the trustee must hold the property for the benefit of transferor. That's why always we say it must be possible to establish exactly what property is subject to trust. Palmer versus Simons, reference is an 1854 case. The testatrix left her property or the residuary estate to her husband for his own use and benefit, but subject to a trust on his death to leave such the bulk of my residuary estate to 4 named relatives. Now the property, the wife executed a last will and said that her residuary property of the estate should be given to the husband for his own use and benefit. On the death of husband, this whatever balance property should go to the relatives, actually those people name already mentioned in the last will. This trust was held to fail for uncertainty of subject matter, and so the husband took the property absolutely. Now the thing is, the first place the property is the balance property or the residuary property given to the husband. That's clear. Then it does not create trust. Once the husband dies, the balance of the bulk of the balance trust residuary property should go to the 4 named relatives. In that case, the trust must be created. But the problem here, what is the amount of property that we are going to give to 4 relatives? That we don't know. Now there is no certain of property. There is no certain in relation to the property. The first place, when you create the trust, the property must be certain. But here property is uncertain because after using the husband, after husband used for his benefit and everything, there's a land, we don't know how much of property will be in balance. That's why the court said that there is no trust because uncertainty of property. The similar results occurred in Spranch versus Bernard. In that case, the testatrix left stock to her husband for his sole use, and all that is remaining in the stock that he has not necessary use for to be equally divided between her brothers and sisters. Now here, the wife given the stock to the sole use and everything for his husband. If anything remaining in the stock, then it should go to the equally, it should be divided to brothers and sisters. But in both Palmer versus Simon and Spranch versus Bernard, the conclusion was reached that the testator had intended the donee to receive absolute interest on which the failed trust were subsequently to be engrafted. Consequently, in both of these cases, husband took property in question absolutely because there is uncertain of property after, because simply we say that husband must use a property. On the death of husband, the balance property should be go to certain relatives. Then the balance property nobody knows. That's why here uncertainty of balance property. Therefore, there is no trust at all. That's why the husband got the property absolutely. However, apparently absolute gifts have sometimes instead been construed as conferring only a limited interest on initial beneficiary. Such construction avoids uncertainty of subject matter in respect of the subsequent trust. Now the thing is, suppose this is the way in which we are interpreting, or the court interpreted the situation. First place we say the limited interest given to the husband. That's the case is given down. In relast, the testatrix left her property to her brother, providing that at his death anything that is left that came from me was to pass to certain other specified persons. The limitation was very similar to that Spranch versus Bernard, but it was in fact construed as conferring merely a life interest on the brother. Consequently, on his death, all the property was held on trust specified by testatrix. Similarly, in the earlier case, Thompson Estate, the 1879 case, a testator left all his property to his widow to be disposed of as she may think proper for her own use and benefit. But should there be anything remaining of said property or any part thereof on her death, it was to be held in various trusts. But the court held that the widow had life interest, together with the power to dispose of property during her lifetime, but no testamentary power so to do. Consequently, any property not disposed during his lifetime was held on further specified trusts. The decisions are obviously only justifiable on the basis that intention of testator was indeed to confer no more than limited interest on the initial beneficiary. Now, even the first two cases, the court decided or court held that there was no trust at all because lack of certainty of the trust property. But if we say that the first beneficiary, the first time the wife executed a last will and the property given to the husband, when you say that the husband has only life interest, then the property may be identifiable. That's why this is a way in which the court interpreted to give effect to the trust. Another method also there to avoid uncertainty of subject matter, that is for the courts to find some way of ascertaining what subject matter of potentially uncertain trust actually is. Now, in Regaliz will trust, that's 1965 case, 1 WLR 969. In this case, the testator directed his trustees to permit a beneficiary to enjoy one of my flats during her lifetime and to receive reasonable income from my other properties. The court upheld the gift, holding that the yardstick of reasonable income indicated by testator was not what he or some other people subjectively considered to be reasonable, but what he identified objectively as reasonable income, something which the court could therefore quantify. This conclusion was undoubtedly inconsistent to the other contemporaneous decisions on certainty, but does seem to be consistent with the more recent practices of the court in trying to avoid, if at all possible, holding a deposition to be void for uncertainty, particularly in respect of expressions such as reasonable or satisfactory. Now, what we have seen in this case, the first one, when you summarize those two situations, generally the general rule is property must be certain. There is no second word at all. But still, when you say the property is transferred to one person, he must enjoy the property, he can use the property or the benefit of the property, and thereafter the balance property should go to another person. Then there is no trust because we don't know what is the amount of balance property. Right? That's very clear. Once again, I would like to say this one. Now the husband, say suppose a person transfer his property very very certain property. This is a land or coconut estate. It was transferred to another person. He must enjoy the property, he can take the benefit of the property, he can use the property, everything he can do. On his death, the balance property should go to the other 4 or 5 beneficiaries. Then the balance property, in the sense, now we don't know at the end of this period or on the death of person how much of property will be there. That's why it is void at all or invalid, because lack of certainty of subject matter of the trust. But if you interpret in a different way, suppose the property transferred to A transfer property B, but B has life interest on that property, then the property is clear. Because we know that what property transferred to B, in that case property is clear, then the B has the life interest, then again on the death of B, the same property will go to the beneficiaries. In that case property is clear. That's the way other 2 cases interpreted. Those 2 cases, Relast and other case, Relast case and Thompson's estate. Those 2 cases decided accordingly. But for the first case, that one, Palmer versus Simons and Branch versus Bernard, those 2 cases, the court said no, the property transferred to somebody, the balance property we can't identify, that's why there is no trust. But other 2 cases, that's known as Thompson's estate and Relast, 2 cases, the court identify only the life interest given to first beneficiary. Then the property is very clear, it should go to the third party. Then there is a certainty in relation to the trust property. Then another way we can say reasonable income. Now say suppose there is the money deposited in the bank. You must take reasonable amount for your lifetime. Then what is a reasonable time? When you should not go to the subjective theory, you must go to the objective theory. How much? Known as reasonable income. Then if the court apply the objective theory, say suppose 2,000 rupees, then you can identify end of the day what is the balance property. That's the way the court try their best to give effect to the trust. Now we will see the next slide here. Boyce versus Boyce here. The test is a device. All my houses probably true, but the report is ambiguous on this point. On the trust to convey one to eldest daughter Maria and other house would go to other daughter Charlotta. Maria died before her mother without making a choice as to which house she wanted. The court held that the bequest to Charlotta failed since there could be no certainty as to which house should be held on trust for her. Both properties were therefore held on resulting trust for testator's heirs, his grandson. And in that case, the property is not clear because they must identify the property, they must choose the property, but they did not do that before that the person died. In that case, they couldn't identify the trust property here. Then in this case, Henry versus Hammond, in this case question is whether you can have a trust over part of the money in the bank account, or is it that the trust money mixed in an account with non-trust money is a fatal to the formation of trust. The court held that if the trust money is placed in a separate account, there will be a trust. If it is mixed, no trust at all. This is another one important case. It was held that only those customers who could prove that their orders of bullion was in fact held separately from the general stores of bullion would be entitled to enforce the trust against the exchange and consequently be able to take their bullion orders away as secured creditors. Now in this case, the people paid money for order of bullion, then it never allocated, just they have ordered, but it was in the stores of bullion, general stores of bullion. Then finally, it was something happened to that. Then the customers asked for this trust on the basis of trust, but it was refused because it was not segregated at all. It was in the general stores, therefore there is no trust created. Always that should be segregated. That is one of the main important factor here. In this Harvard Securities case, the dealer in financial securities held securities as nominee for his client, while terms of the contract suggested that dealer held the securities on bare trust for each of his client. The securities was not numbered and was not separated. Again, securities were not numbered and were not separated. In consequence, none of the clients were able to identify which securities were held on bare trust for which client. It was held that trust was not invalid for uncertainty of subject matter because the securities were intangible property, therefore did not require segregation. Now there's another concept that we must understand: tangible property, intangible property. If there's a tangible property, then that should be segregated. If it is intangible property, then you can't segregate at all. No need to segregate at all. The situation with tangible property is relatively clear. In London Wine Company, that we'll see later, and the next one, I think that's the case. Now, for the purpose of clarification, we will see here, the wine dealers sent letters to purchasers of wine confirming that they were the sole beneficial owners of wine which they had bought and paid for. However, no steps were taken to segregate the wine in question from the general mass of stock held by dealers. It was held that no trust had arisen, so that purchaser had no proprietary rights in the wine as against the holder of floating charge, which the dealer has granted over their entire assets. Like earlier cases, a case also we have seen in gold crop exchange. They had purchased but had not been delivered or had not taken delivery of unascertained bullion. Save for the group whose bullion had been segregated, there was no identifiable property whatever to which any trust could attach, and the remaining purchaser remained unsecured creditors in the bullion company's insolvency. That we have seen earlier, the bullion stores we have seen, the people paid money, but the dealer also agreed to allocate that one, but never segregated. In the case now, what we have seen in the Real London Wine Company also, the purchaser, they have paid and bought the wines, but it was in the general stores. It was not segregated at all. Therefore, the court said that it is a tangible property. Therefore, if it is tangible property, that should be segregated. If it is intangible property, then it is not necessary to segregate. That case, I think we will see in later, but now we will, for the purpose of understanding, we will see that the position with intangibles is more controversial. Hunter versus Morse, a declaration of trust in respect of 50 shares in the company, in which the settlor held 950 shares, was upheld on the basis that any identification of particular 50 shares held on trust was unnecessary and irrelevant. For instance, the principle enunciated in Real London Wine Company was confined for tangible property. Then in that case also again, in the Hunter versus Morse, he has given only 50 shares to company shares to somebody, but altogether he had about 900 shares in the company. But in shares, when the sense that's a intangible property. Therefore, no need to segregate about 50 and put it somewhere else because it is intangible. Sometimes they may give some certificate in one certificate, or sometimes it may be different certificates, but still intangible property. Therefore, there is no requirement of segregation. That is the Real London Wine Company case. A wine merchant bought and held the wine for clients for their orders. Stock of wine was held together without distinguish which particular bottles were held for which client. The wine merchant company went into liquidation, and the claimant argued that wine they have ordered from shipper was held on trust for them under terms of their contract. However, creditors said that it belonged to the company and was a part of company's asset in insolvency. Held that there could not be a valid trust because claimant could not identify which wine was held for them out of the general store. It would have been necessary for the claimant's wine to be segregated, that is, to be separately identifiable from the general stock. Branch versus Bernard, we have seen already. This is also remaining property. That's the court said that this statement was too uncertain for the trust to take effect over any part of the property because the property was not sufficiently clearly identified by the remaining part of what is left. Therefore, the clear idea is, now we must see the clear idea here. Trust property always must be certain. That's the general rule. If you say remaining property or remaining part of the property or whatever it is or balance property, then there is no valid trust because lack of certainty of subject matter of the trust. But if you say that the first person, the property transferred to somebody and for the use of that person, then in that case, if you interpret that, suppose A transfer property to B, then B holds the property, and B has the life interest only, then the property is clear, that we have seen. Now, tangible property, intangible property. Tangible property, you must know that very clearly, that should be segregated and it should be identifiable. Not only segregated, but also it should be identifiable. But if it is intangible property, then no need to segregate. That's why we have seen the company shares and securities. Hunter versus Morse, that we have seen 50 shares out of 190 shares of to the financial director. Employer did not transfer the shares, nor were attempts made to identify those shares which were to be subject to the arrangement. An issue arose as to whether or not finance director could assert the proprietary rights over 50 shares. If he were to apply the rule of Regaliz, that's the bullion case, to these facts, then there would have been no valid trust over the shares, because it was impossible to know which 50 shares out of total holding of 950 shares were to be held on trust. But still it is a intangible assets. That's why it was held on trust over the shares had been formed, because the different approach was taken from that set out in Gold Corp and held that there was a valid trust, because the gold corp, that's a bullion, that's identifiable, and that's a property, tangible property, then that should be segregated and kept separately. But here, if it is shares or securities, otherwise. This is also one of the case here. A buyer purchased and executed a trust deed declaring its subject matter to belong to her grandchildren. She wrote her solicitor saying that I wish to cancel the trust of the house. The existence of the trust was not disclosed at all. When she obtained series of court orders for possession and the profit for use and occupation, the property was sold in 2006 for a price. Mother died in 2009. But in 2012, wife discovered existence of the trust deed. Then what happened? She successfully applied to have the decision to set aside on the basis of fraudulent non-disclosure of trust deed. Unfortunately, trust deed, which was drawn up, failed to mention the subject matter of the trust. The Court of Appeal held that background of the circumstances and the correspondence at the time the deed was drawn up lead to the conclusion it had to relate to the property, so long as intent of the parties can be identified from the background of the circumstances, court will be then loath to find the deficient document is ineffective. The Court of Appeal effectively decided that trust had been established by conduct. But the thing is, even though the property was not clear, here the property is clear to some extent. That's why the wordings are not clear, but mentioning the subject matter and everything, but court interpreted such a way and established and declared that trust has been established by conduct. Now we will see what is happening in the absence of certainties of certain matter. Suppose if there's a lack of certainty of intention to create the trust, what is next? Then there is no trust at all. Because first of all, the author of the trust must have the intention to create the trust. If it is not there, if there's anything lack there, or if you are unable to prove that part, that means there is no trust at all. Say suppose A transfer the property to B. But if A fails to prove the intention to create the trust, that means there is no trust. That's an absolute outright transfer at all. Then second thing we will see, if the beneficiaries are uncertain what's the situation, then we have seen resulting trust. If the beneficiaries are uncertain, then the trustee or the transferee must hold the property for the benefit of transferor, that's the owner of the property. Then if the property is uncertain what's the situation, there is no trust at all, no trust at all. In the case of Fernanda versus Supremo, it was mentioned that no particular formalized record by law for the creation of trust. The requirement of law is that the author should make his meaning clear and evince his intention to create the trust, and the court will give effect to that intention. In the instant case, Kanapati, the author of the trust, declared by P1, has clearly indicated that the purpose of granting land in question to himself and to another was for the advancement of religion and maintenance of religious rights and practices of Hindu faith. The beneficial interest is not vested in any ascertainable individuals, but in uncertain and fluctuating body Brahmins. Under the law in force in 1888, he was entitled to create in that way he did. That's an old case. Then the Grand William in his the Three Certainties has suggested 3 ways by which uncertainty as beneficial interest may be cured. The first one, where the trustee is given the discretion, to apportion to the property among the beneficiaries, then the trustee has the right to take the decision on that. Then the court cures uncertainty by applying the maxim, equality is equity, dividing the property equally. If all beneficiaries are competent to conduct, there is no issue at all. They can come together and divide or select or elect according their amicable settlement. That's why here, if all the beneficiaries are committed to conduct and are collectively absolutely entitled, they may elect to apportion the property among themselves in a definite manner. Then Pulle versus Pereira testator bequests certain specified person all the rents and profits arising from the properties, and further directed that the share of the rents of legatee dying should be distributed among the widows and really deserving destitute people in the burgher community. Discussed with the executor, but held that trust in favor of burgher community was not void on the ground of its being vague, because it is clear to identify the burgher community and they can be beneficiaries of that of the trust. Then what we have studied now, when you summarize in relation to this trust property always must be certain. That's why in the section 6 also we say that trust is created when the author of the trust indicates with a reasonable certainty by any words or acts the trust property. The trust property must be certain. There is no second word at all. But still, that's why we have seen 2 cases. Those 2 cases we have seen trust property must be certain. Palmer case and Sprange case. Those two cases, court rejected the trust because lack of certainty of the subject matter of the trust property. Then other two cases, the real last and Thompson's estate. In those two cases, court applied life interest because the property transferred to another person, then he has the life interest, he can enjoy the property, he can use the property, he can take profit and rent and everything, but ultimately the property is there. Then on the death of B, the property should go to the beneficiaries. That also clear. The property is clear. Then the court gave effect to the trust that we have seen. Now, the reasonable income, if say that any person, the money deposited, then you can get reasonable income from that money, that's also permissible because you don't apply the subjective theory, you must apply the objective theory. Then court decide that this is a amount required for 1 month, then end of the period, this is a money in the saving account, therefore that property is certain, then you can give effect to the trust. Then we have seen tangible property, intangible property. Tangible property, if there's a trust property is a tangible one, then the clear idea is that should be segregated and that should be identifiable. That should be segregated and that should be identifiable. If it is intangible, that also we have seen for tangible cases, we have seen Gold Cope exchange, that a bullion case that we have seen, and also we have seen London Wine Company's case. The two cases, the property is tangible, that's a wine, and the bullion. Then those two cases, it should be segregated. It was not. That's why the court held that there was no trust at all. But in the tangible property that we have seen shares and securities, in Hunter versus Morse, that is the share case, 950 shares out of 950 shares, 50 shares transferred to somebody for the benefit of somebody else. That's court held that no need to segregate because it is intangible property. And also we have seen security case also we have seen. In that case also security in the sense you can't divide or you can't segregate that one because it is intangible property. That is the matter in relation to the property. Then today we have completed these reasonable certainty of intention to create the trust and purpose of the trust, beneficiary and trust property. Thank you very much.